Good morning and welcome. I'm Dean Reuter, Executive Vice President of the Federalist Society. It is my distinct pleasure to welcome you to this year's Federalist Society National Lawyers Convention. I also want to welcome everyone tuning in on the live stream. And of course, I want to give special thanks to our donors who have made all of this possible. Thank you for your support. Now, I think people in this room know that this is the second year of hosting the convention at the Washington Hilton Hotel. And last year, in opening the convention in this very room, I shared a story about the daring human beings, 102 souls, who boarded a small vessel in Europe in 1620 and set sail for America. 10 weeks later, surviving the extremely cramped confines of that vessel, the Mayflower ship, they made it to their destination, America, and their adventure continued. Like those adventurers, the Federalist Society made a parallel journey last year, not leaving the cramped quarters of the Mayflower ship, but leaving the friendly confines of the Mayflower Hotel. Continuing our journey and arriving here last year. So thank you for that laughter. But now I come to you with good news this year and bad news, so mixed news. We listened to your feedback, and the good news is we're taking the daily National Lawyers Convention back to the Mayflower Hotel starting next year. The bad news is the 2026 convention is sold out. That's a joke, of course, that part about being sold out. But in seriousness, please do yourself a favor and do me a favor. When you get the registration next year for the convention, register immediately. Just do not say to yourself, oh, I'll register as soon as I finish this oral argument, or I'll register as soon as I step out of this clerkship interview, or when this wedding ceremony concludes. Just stop, get your phone, and register. Now, importantly, I want to take a moment and thank the staff of the Federalist Society. They've been working hard on this event for years. They're in the room, a handful of them, but I want to give them a round of applause. They're doing their best to make your experience a terrific one. They're wearing the red ribbons on their badges. As I like to say, ask them for help, directions, any minute detail about the facilities or the programming, and I guarantee you they will pretend to know the answer. Now, on a few logistical items, if you're seeking CLE credit, you've got access to the QR code. Make sure you sign in the morning and then sign out every evening. You got to do that every day. Use the convention app. If you haven't downloaded the convention app, I find it very handy. So download the app and use it for updates on the programming. Now, turning to our programming today, and this over the next few days, the theme of the convention this year, you all know, is New Legal Frontiers. And we begin the day of programming, full day of programming today, culminating in our annual Scalia dinner this evening with over 2,400 of your closest friends. I like to say, you've heard this before, but to me, the Federalist Society convention is like a family reunion. Only these people you actually like. So welcome in. Now, appropriately, you'll notice a few things at this year's convention as we examine New Legal Frontiers. A lot of changes, new topics, new speakers. You'll see a lot more involvement from students and younger lawyers who will be moving us all into the new frontiers that define the convention's theme this year. And speaking of new frontiers, new beginnings, continuing journeys, I'm personally thrilled to have Sheldon Gilbert at the helm of the Federalist Society as our new CEO and president. I know he's in the room somewhere. If you haven't met Sheldon, I hope you have the chance to meet him over the next 3 days. He is a ton of energy, a lot of great ideas, and tremendous leadership at the top, and we're so happy to have him here. I've known him for 15 years, 20 years maybe. As you get to know him, I know you will come to the conclusion that the Federalist Society is in very capable and strong hands. So the journey continues. In fact, that journey never ends. Kicking us off this morning, though, giving our opening remarks for this year's convention is Judge Patrick Bumatay, and it's my distinct honor to introduce him. I don't know why he's sitting so far from me, but he currently serves on the United States Court of Appeals for the Ninth Circuit. Prior to that appointment, he served as an assistant United States attorney in the Southern District of California. He also served as counselor to the Attorney General on criminal law issues and worked in the Office of the Deputy Attorney General, the Office of the Associate Attorney General, and the Office of Legal Policy, all at DOJ, where he twice received the highly coveted Attorney General's Distinguished Service Award. Judge Bumatay clerked for the Honorable Tim Timkovich on the 10th Circuit, and I think that judge is with us as well today, and the Honorable Sandra Towns in the Eastern District of New York. He earned his BA from Yale and his JD from Harvard Law School. Very pleased to welcome you here today. Please join me in welcoming Judge Bumatay.
Thank you, Dean, for that introduction. It's such an honor to be giving these opening remarks. It was more than 20 years ago that I attended my first Federalist Society National Convention as a student. I still remembering roaming the halls of the Mayflower Hotel, seeing friends, chasing down legal luminaries, and to be honest, mostly skipping the amazing panels. But I never imagined that one day I would return as a judge and give these opening remarks. I thank the Federalist Society for this amazing opportunity. And it's great to see so many friends and fellow judges here at this conference. My old boss, Judge Timkovich, is here. He's somewhere out there. There he is. Judge, it was truly an honor to clerk for you. Everything I know about judging, I learned from you. You're simply a model of excellence for our judiciary. Thank you for your over 20 years of service to our country. Let's see if there's anyone else. Is my good friend Judge Van Dyke here? He was planning on coming, but I think he couldn't get through the metal detectors. Actually, I remember he's not here because he's busy accepting his Oscar for Best Video Dissent. Have you seen it? It's his best acting since his confirmation hearing. And Judge Thapar and Judge Oldham are here. They're the guys in the back doing the burpees. Hello. Unfortunately, their clerks aren't here. They're still recovering from their chambers-wide 3-day fast. Judge Newsom is also at the conference. I'm sure he'll agree with everything I say this morning, but he'll write about it in a 100-page concurrence to his latest opinion about arbitration clauses. And sadly, Judge Jim Ho is not with us this morning. You see, I went to Yale, so even I'm on his boycott list. But seriously, it's a true honor to give these opening address. For these remarks, I would first want to reflect on the upcoming anniversary of the Declaration of Independence. It's hard to believe that our nation was founded only 250 years ago. When I think about the Declaration, I can't help but think about my family's story in the United States. There are through lines between the principles expressed in that Declaration and the American exceptionalism that my family has experienced firsthand. Almost a century ago, my grandfather came to the United States from the Philippines. He crossed the Pacific with nothing more with the luggage in his hands. He landed in San Francisco and found work as a farm laborer, picking fruits and vegetables across California's farm fields. But he didn't stop there. Through hard work and resilience, he put himself through college, then even earned a PhD. He then returned to the Philippines to start his family. Years later, my parents immigrated to the United States. They moved to New York. Unlike my grandfather, they had medical degrees, but with their education, with their faith, their family, and a work ethic, they built a beautiful life for me and my sister. So I grew up deeply grateful for our country. That gratitude is what led me to dedicate my career to public service. As Dean mentioned, I spent most of my professional life as a federal prosecutor in San Diego, taking on the cartels, trying to ship dangerous drugs into our country. But I also served in Main Justice here in Washington, D.C. I worked with the Associate Attorney General, the Deputy Attorney General, and the Attorney General, the top 3 officials at the department. For baseball fans, I like to say I hit for the cycle at the DOJ. And for the past 6 years, I've had the privilege of serving as a judge on the 9th Circuit. All opportunities I could have never imagined when I was a student sitting in your seats 20 years ago. So you can see, the American dream has struck my family 3 times. First with my grandfather, second with my parents, and third with me. As my family's experience shows, this is truly an exceptional nation. And with our country's 250th anniversary right around the corner, we should celebrate that the principles of the Declaration of Independence are a large reason for that. The Declaration inspired and nurtured the culture of individual rights and freedom that define our country today. It promises that we are all equal in the eyes of our Creator, and that we all have certain fundamental rights to life, liberty, and the pursuit of happiness. And it was the Constitution that transformed those promises into a binding law. As Abraham Lincoln put it long ago, the Constitution is the picture of silver framed around the Declaration's golden promises. It was a legal framework created not by force or coercion, but through deliberation and consent. And that's why I'm an originalist. Government authority derives solely from the consent of the governed. To respect this, judges must follow the words of the Constitution as the people understood them until the people decide to change them. Failing to do so puts the judge's will above the people's. We are thus bound by the original meaning of the Constitution. And so I'm an originalist because my oath to the Constitution commands it. It's no exaggeration to say that we are in the golden age of originalism. Most of the justices of the Supreme Court now openly identify themselves as originalists. Even the other justices acknowledge, at least in some ways, that our law must be grounded in historical meaning. Originalists also populate the lower courts. And unlike when I was a student, originalism is now taught and must be reckoned with in academia. In short, originalism has won the day on the battlefield of ideas. So it's fitting that the theme of this year's convention is New Legal Frontiers. Today's originalists face a new set of questions. What does originalism look like as the dominant judicial philosophy? What happens when we're no longer the underdog? How do we move originalism from a critique to a governing doctrine? The answer, we must be bold. To continue this golden age of originalism, we cannot rest on our laurels. After all, no victory is permanent. So what does it mean to be bold? Justice Scalia famously dubbed himself a faint-hearted originalist because he sometimes struggled with its consequences. But he joked that Justice Thomas was a bloodthirsty originalist, because of his unwavering adherence to the original public meaning of the Constitution, come hell or high water. And Justice Thomas took it as a compliment. I would too. After all, is there any higher praise than being called ruthless in your search for the right answers about the law? This fierce commitment, this bloodthirsty originalism, is exactly what we need. Whether you're a judge, a student, an academic, or a practicing attorney, we must all be diehard champions for the Constitution. So what does it mean to be bloodthirsty? Let me tell you 4 ways. First, it's time that we put the mantra of judicial restraint in its place. Judicial restraint rightfully rose to prominence as a reaction to the Warren Court's excesses. It served as a bulwark against the judicial activism of the era. Some promoted originalism as a way to achieve judicial restraint. They thought it would lead to narrow rulings, prevent judicial innovations, and promote democratically enacted policies. And to be sure, originalism is a constraining philosophy. In fact, I would argue that it is the most constraining of any judicial philosophy. But because we appeal only to the Constitution's original meaning, amorphous concepts like constitutional purpose or living constitutionalism are replaced by a more objective inquiry into textual meaning. But originalism and judicial restraint don't always go hand in hand. Because judicial restraint focuses on prudential or political considerations, it doesn't ensure that we are following the original meaning of the Constitution. So it can prevent judges from reaching the results required by the Constitution's text and historical understanding. While it's wise to remember that judges are unelected and that we are the weakest branch, we can't ignore that our highest duty is always to the Constitution. And we must acknowledge that we are now in a different time. Judicial restraint isn't always a virtue in itself. Fidelity to the Constitution is. Moving forward, we can't confuse the two. So we must be willing to disregard judicial restraint whenever it gets in the way of following what the law is. Second, bloodthirsty originalists must not hesitate to overturn non-originalist lower court precedent. Judges don't work with a blank slate. We often encounter non-originalist bad decisions. And trust me, as a Ninth Circuit judge, I have that problem more than most. And to be clear, I'm not talking about vertical stare decisis. No serious originalist judge would question our duty to follow the Supreme Court. As Justice Gorsuch recently said, lower court judges may sometimes disagree with the Supreme Court's decisions, but they are never free to defy them. What I am talking about is horizontal stare decisis. By that I mean, when should circuit judges overturn their own non-originalist precedent? Spoiler alert, the answer is always. We've all heard about the stare decisis factors. The true legal nerds among us can recite them by heart. The nature of the legal error, the quality of the reasoning, its workability, its disruptive impact, and reliance interest. But it's important to remember, these factors should be applied only by the Supreme Court to overturn Supreme Court precedent. For lower court judges, however, the stare decisis factors should all collapse into one. The first one, the nature of the legal error. So for lower court originalists, this makes horizontal stare decisis easy. If the circuit precedent fails to adhere to the original meaning of the Constitution, it should be overturned, period. The reason is simple. The same considerations that justify Supreme Court stare decisis do not exist for the lower courts. The Supreme Court governs the whole judiciary, and it must consider its nationwide impact. It takes far fewer cases, and it typically only reviews issues after they've percolated through the lower courts. Meanwhile, lower court judges are in a different league, the minor league. We handle a much bigger, non-discretionary caseload, and we can create binding law with as few as 2 judges. Circuit judges also preside over small, geographic subdivisions of the country, limiting our impact. Further, we often immediately review our decisions through the en banc process, diminishing reliance interest in those cases. Lastly, we're not the final word. The Supreme Court can always intervene if it disagrees with our decision to overturn our own precedent. So while the Supreme Court jumps through the hoops of the stare decisis factors to overturn its precedent, lower court judges are free from those constraints and should always vote to overturn non-originalist precedent. After all, can't always rely on the Supreme Court to clean up our messes. In the Ninth Circuit, we have a rule that we must sit en banc to overturn precedent. So this might mean that we should call more cases en banc. I understand that seeking en banc review may have ramifications for collegiality on the court. I know the sting of having a decision that I've written be later vacated en banc. And collegiality is important, but it's not the end-all and be-all. To me, collegiality is more about how we treat each other when we're off the bench, outside our writings. In those situations, we must always treat each other respectfully. But that doesn't mean that we should fear disagreement or that we should avoid vigorously highlighting our differences. After all, our duty is always to the Constitution, so while there may be a time and place for compromise and pulling punches, that's rarely the case when defending our Constitution. Third, even when we are bound by non-originalist precedent, there's still a major role for originalism to play. In applying precedent, we must bend it in the direction of the original public meaning. That doesn't mean that we could take a cramped reading of precedent to functionally overrule it. But neither should we take an overly broad view of that precedent, allowing to expand to new areas. Instead, if we could find a good faith distinction, we should do so and return closer to first principles. As I said, our duty is to apply the Constitution, not to extend precedent. Justice Kavanaugh had it right when he explained that text, history, and tradition must function as the gravitational pull on our interpretation of precedent. So we can respect precedent even while pulling it in the direction of the Constitution's original meaning. So we don't need to wait for cases with a complete blank slate or questions of first impression for the Constitution's text and history to come into play. Fourth, we shouldn't let party presentation principle override the need to reach correct legal decisions. You may hear judges talk about how they would love to follow originalism, but they can't, simply because the parties haven't presented any historical analysis in their briefing. To me, that's no excuse. While it is of course true that the parties must bring a case and focus the issues, that doesn't supersede our duty to follow the law. I recognize the Supreme Court has recently given the party presentation principle some new teeth. In the United States versus Senanang Smith, the court relied on the principle to strike down a Ninth Circuit decision as an abuse of discretion. In that case, my court completely overreached by refashioning the parties' issues to get to a desired outcome. But some lower court judges have overread its importance. Since it's come out, Senanang Smith has been cited over 800 times, and in many of those instances has been misused. It cannot be right that the parties control everything about the case, even the meaning of governing law. One extreme example comes from a DC Circuit case. There, a very well-respected judge wanted to decide a case relying on a repealed statute. The judge reasoned that because neither party had raised the law's repeal to the district court, it was inappropriate to consider it. This effectively accepts that a judge is bound by the party's stipulations to the law. But that's wrong. Judges are never obligated to follow the party's agreement to incorrect law. After all, the parties don't need to ensure the best interpretation of the law. Judges do. So even though judges generally rely on the arguments the parties advance, we should never cede our duty to independently interpret the law. In my view, once a party raises a legal theory, judges may consider anything subsumed by that theory. So we can't completely refashion the party's claims, issues, or legal theories. But within a particular theory, judges may consider any arguments, any sources, any authorities that may be helpful, including those not raised in the briefing. So even the parties don't specifically make originalist arguments in a constitutional case, judges are free to, and indeed must, engage with a historical understanding of the constitutional text. If our job is to get the law right, then we cannot allow the parties to lead us astray with bad or incomplete arguments. Just like we wouldn't ignore a dispositive case if the litigants failed to brief it, we shouldn't close ourselves off from any historical evidence which would guide us to the right conclusion. So regardless of the parties' arguments, we always retain the independent power to identify and apply the proper construction of governing law. After all, judges are not like lemmings, following the parties off of the jurisprudential cliff. In sum, we must be fearless advocates for the Constitution. It wasn't long ago that Justice Scalia stood all alone, insisting that the Constitution means what it says. But as I said earlier, it's truly a golden age for those who believe in originalist principles. And yet, even after all that success, we face those that say, yes, I'm an originalist, but there's a time and place for originalism. Or, I'm only going to analyze the Constitution's original meaning when there's a true blank slate. To the judges in the audience, I'm here to say that we can do originalism, not once or twice in a career, but once or twice in a day, be it in a majority opinion, concurrence, or dissent. People sometimes misunderstand what it means to be a bloodthirsty originalist. It doesn't mean you take the most extreme position on judicial principles. But I think Justice Thomas embraced that label because it means you're always an originalist, not just when convenient, not just when it suits your policy preferences, and not just when there's a blank slate. Before I close, I'd like to talk to the students in the audience. My message of being bold isn't just for the judges, it's for you too. I know you've dealt with a lot these past few years. I know you might feel besieged on campuses, but I hope your time this week will embolden you to return to your schools and keep advocating for your principles. Organize events, debate your peers, and don't be afraid to stand up for your values. As you will see here, you're not alone. And then, when the debate is over, go have a drink with your fellow students on the other side. I spoke earlier about collegiality among judges. We can be fierce adversaries in our writings, but friends outside of them. That goes for students as well. In the more than 20 years that I've been coming to this conference, so much has changed because there's been generations of students like you willing to carry the banner for what they believe in. In other words, be the leader of the new frontier, and be bloodthirsty leaders at that. For experienced leaders, experienced lawyers and academics here, you have a critical role too. helping the next generation to be bold. You have the capital, the resources, the authority to stand up for them, guide them, and support their efforts in your schools, firms, and beyond. It falls on you to nurture the next generation. In addition, push originalism in your scholarship and briefs. Originalist scholarship and briefing pave the way for judges to undertake a more balanced, thorough analysis of the Constitution's historical meaning. Finally, I want to end these remarks by challenging all of you. I recently read Frederick Douglass's "What to a Slave is the 4th of July?" It's Douglass's remarkable speech about the Declaration of Independence. Read it if you haven't. Speaking in the 1850s, he observed that the nation was still young, only 76 years into the American experiment. As he said, it was a mere speck in the broad sweep of history. He argued that our country had failed to live up to the promises of the Declaration of Independence. With the evil of slavery still in existence, not everyone enjoyed the rights that it declared. Instead of decrying the Declaration, he pushed everyone to embrace its ideals because he knew that it would lead to greater freedom and justice. He told all that would listen, stand up for those principles, be true to them on all occasions, in all places, against all foes, and at whatever cost. We should be proud of how far this nation has come. At almost 250 years old, I like to think that we are still a young nation, so we can still strive to reach the Declaration's highest ideals, still become the more perfect union the Constitution proclaims. Now is not the time to be complacent. In fact, it's time to double down. At this coming semi-quincentennial, we should follow Frederick Douglass's example and dedicate ourselves to our nation's first principles. Being faint-hearted is not the answer. If we truly believe in our country, we must defend the Constitution on all occasions, in all places, against all foes, and at whatever cost. Thank you for having me, and enjoy the conference.
Thank you so much, Judge Bumatay. That was terrific and inspiring. We're going to continue the day and start our next showcase panel without a break. So if people remain in their seats, and we call the panelists forward.